Welcome to this evening's Social Context of Law event titled Handing Back the Past, Cultural Repatriation. For those of you not familiar with the way these events run, we'll have a chairman to whom I'll introduce you in a minute, and he will then explain what happens. But there does come a time when there's question and answer. And we have a very relaxed approach to question and answer. You are restricted to 30 seconds, quite literally, and you don't say who you are or thank them, because that you can do that at the end, or say how good their speeches are, because that's a bit patronising. What we want is just a 30-second question, and whoever's dealing with the questions, I think James, will allow students who've got their 30 seconds prepared to go first. So let me introduce you then to your chair. Professor James Lee is Professor of English Law at the Dickson Poon School of Law, where he teaches several private law subjects and is currently the school's acting Associate Dean for Research Impact. He's an academic bencher of this Inn and an academic member of the Property Litigation Association, Chancery Bar Association, Property Bar Association, and for those with their questions ready to go at the beginning, he serves on the Education and Training Committee. James.
Thank you very much, Master Nice, and thank you for creating and curating this lecture series. It's a pleasure to see so many people here in the room and imagine so many people also here online. The format will be, we'll have short presentations of 15 minutes or so from our two wonderful expert speakers who I'll introduce in a moment. And then I'll ask a couple of questions just to illustrate what questions are like. And then we'll have some back and forth, and then we'll open up the floor. The topic is handing back the past, cultural repatriation. And this is an urgent topic that really matters to a lot of people with lots of different perspectives. The aim of this session is to discuss the moral political questions, but in the context of the legal complications that cultural institutions may face, particularly statutory charities such as most of our very well-known museums, for example. So we recognise the emotions that will be underlying a lot of this debate, but we want to make sure that we're doing it in a way that is sensitive and respectful throughout, and that is our aim. So, our speakers, whom I'm delighted to welcome this evening, are first of all Mona Yapova, who is an art law specialist solicitor at Mishcon Reya. She is a graduate of two fine institutions, the Courtauld Institute of Art and also King's College London, where I'm very proud to have taught her in her English and French law degree. Having nearly been an artist herself, she rightly picked the law and then has forged a stellar career as a specialist art lawyer, first through boutique firms and now at the leading firm Mishcon. She's also still very active in lecturing for the Courtauld Art Law Society. We'll hear from Mona first, but I will introduce our second speaker before she does so. Our second speaker is also a master of this Inn, Casely-Hayford, who is currently director of the V&A East, the Victoria and Albert Museum East. He has many garlanded honours, which he prohibited me from speaking, but I'm the chair, so I can name them. He is an OBE. He has a doctorate from the School of Oriental and African Studies, as well as being a professor of practice there. Even more importantly, he's a cultural fellow of King's College London, and he has many other stellar achievements throughout the art world. So we have two contrasting but wonderfully eminent speakers here this evening. We're very lucky to benefit from their expertise. So, firstly, we'll invite Mona and then Gus. Thank you.
Hi, good evening. Thank you so much for the generous introduction, Jamie, and thank you for having me. It's a real honour to be here. I have prepared a short overview of the topic. I have tried to resist as much as I can, not going into the art historical background to give you the pure legal perspective, but hopefully that will give us a good start for the framework that we typically work with in this type of conversation. So most important thing to start with is to say that cultural repatriation and restitution is probably one of the most layered topics that I come across in my field and that I know many of us here have interacted with. Although we have tried and continue to try, it's often not a topic that can be resolved by the law alone, and or at least the law is not yet fit to do it justice fully. Disputes and conversations about restitution and repatriation have for many years been stuck behind legal hurdles, but we're seeing changes in that regard. It's increasingly being approached from a cross-disciplinary perspective, so taking into account art historical, cultural perspectives in an effort at finding more balanced solutions. As an art historian, as I mentioned, I couldn't resist mentioning this, but from now I'll censor myself a little bit more to focus just on the law. There's a history to the legislation that led to the complex and legal framework that we work with today. It took a long time to start legislating on the international protection, especially of cultural heritage. As is often the norm with legal reform, we've legislated better for the future than we can for the past. But when we speak of looting, we often naturally think of looting during many historic instances of armed conflicts, such as colonial era looting, Roman conquest, Napoleonic wars, all of which precede the history of international efforts to regulate the protection of cultural property. That encompasses many years of established practices of what we sometimes, like today, call looting, can be forcible taking, confiscations, takings under duress, many different contexts in which cultural heritage is removed from its country of origin. But often, the countries that have suffered those removals have had laws that regulate for theft, etc., similar practices, but it's not often been as easy as relying on the law to resist that taking, to actually take legal action based on those regulations. And what's become increasingly apparent and important is the importance of international cooperation to enforce that protection. And that's both at national and international levels. So it's the international regulations that we have on the kind of transnational level, but it's also how they translate into national legislation and how they might influence it. The international efforts to consider regulating heritage started towards the end of the 19th century with things like the Lieber Code in the United States in 1863, the Brussels Conference of 1874, the work of the Institute of International Law, and other early comprehensive treaties on the law of war, like the 1880 Oxford Manual. And those early efforts didn't, unfortunately, all translate into binding rules, but they laid the foundation. They started the conversations that led to things like the Hague Conventions of 1899 and 1907, which was one of the 1907 convention especially, was one of the first instruments that had rules about the protection of cultural heritage. By the 1950s, more states that had been under foreign rule were gaining independence, and concerns related to the growth of the black market during this time, that's the black market in cultural heritage, began to rise. And in particular, this related to, for example, dismemberment of monuments and ancient sites to meet the demand on that black market. The first international convention that was purely dedicated to cultural heritage protection was the 1954 Hague Convention for the Protection of Cultural Property in the Event of Armed Conflict. The focus of that convention is on how to protect heritage during times of war. So it includes a lot of provisions about how to mark heritage that should be protected. Military personnel is often trained on the basis of that convention. So it's a convention aimed at protection. It does contain some provisions about return of property that's taken in that context, but it's mainly aimed at prevention. The issue of protecting heritage plunder during times of peace, however, remained after that convention, and that's how we came to the 1970 UNESCO Convention. That's probably one of the most well-known ones. what it set out to do was to curb the illicit trade in cultural property, especially illegally exported cultural property. The difficulty with the UNESCO Convention is that its material and temporal scope, which, if it's of interest, I can elaborate on later, was a little bit too narrow. The value of the convention, however, has been huge in terms of standard setting. It's one of those conventions that we often refer as benchmark conventions, because it created guidance for countries on how to monitor and control heritage on their territory, created soft law, and it helped establish best practice on cooperation between states. For example, most major museums now will refuse to acquire property that has left the country of origin after 1970 without documentation on how it's been exported, where it's been exported from, if it's been excavated, if that's been done legally, etc. What came after was the 95 Unidroit Convention, which unfortunately didn't have as much support as other conventions. Some important market states aren't signatories of that convention, but its aim was to rectify some of the shortcomings in the scope of the UNESCO conventions. And importantly, it brought private parties into the regulatory equation a little bit more. That's a huge shift in the burden placed on collectors. So not thinking only about museums, but also of private parties that interact with the market. And that increased the burden of due diligence on collectors with time. In 1998, a number of governments, over 40 governments that participated in a Washington conference on Holocaust-era looted art, reached a consensus on and endorsed 11 non-binding principles that are called Washington Principles that assist in resolving issues surrounding specifically Nazi-looted art. Although they're not binding, they've been very important at guiding the countries that subscribe to those principles in how to refine their national legislation to deal with the very complex historical, legal, etc. framework when it comes to Holocaust-era claims. The UK was one of those participating countries, and we have legislation, which I'll mention very briefly later, that has come after those principles. These are only some of the key international instruments in the sphere of restitution. The European Union has also passed directives about the return of cultural objects. We have a regulation that's about to come into force at the EU level again on the import of cultural heritage that regulates the import of cultural heritage that's been illegally exported from its country of origin, that places quite heavy burdens on importers, which can be private parties, to prove that the object they're trying to import was legally exported from its country of origin, no matter when that happened. That could be hundreds of years ago, it could be 20 years ago, and that's encouraging a very careful due diligence about the source of objects. In the UK, the regulatory framework for restitution remains limited, and it's often not designed to take into account all the intricacies of historical events, because much of it is still general, meaning it's designed to apply to all types of restitution. There are several civil and criminal statutes that regulate the liability of private individuals, but the key current limitations that we often speak about the most is national museums' restricted powers to deaccession works. For example, under the National Heritage Act of 1983, the trustees of some national museums in the UK are specifically prevented from deaccessioning works, except in very, very, very limited circumstances. So that's, for example, objects that are duplicates or irreparably damaged. An equivalent provision restricts the British Museum under the British Museum Act of 1963. This is not to say that this rule can ever only be a blanket rule, and we have legislation, for example, such as the Holocaust Return of Cultural Objects Act of 2009, that creates an exception to this rule, in that it gives museums an additional power to return objects where the decision to return is endorsed by what we called the Spoliation Advisory Panel, which is a cross-disciplinary panel. If they endorse and recommend that return, and that return is also approved by the Secretary of State, then that allows returns as an exception to that rule that bars deaccessioning. This is a very good example of a tailored framework designed to address and recognize the intricacies of a specific historical event within the general framework. The result of the restriction placed on national museums is that we see objects that have a common history, for example, like Benin bronzes, that were taken during the punitive expedition in Benin City in 1997, that face different barriers to repatriation depending on the institution that they're in. So, for example, claims for repatriation and restitution have been made to the British Museum, the University of Cambridge, the Horniman Museum recently, and of course museums across Europe, but only the University of Cambridge was able to return over 100 Benin artifacts. The Horniman Museum has been able to restitute 72, but the British Museum hasn't been able to honour those claims in the same way. This is partly because charity law allows institutions in the UK that are not national museums to apply to the Charity Commission to make what we call ex gratia payments, which are based on moral obligations, and that can include returns based on a decision to deaccession, following a decision to deaccession. Recently, and for a moment, the government considered giving national museums the power to apply to make those ex gratia payments on the same basis under the Charities Act 2022, but eventually retracted this. This brief overview illustrates the patchwork of laws that our framework is made of, both nationally and globally. The most important national collections are often locked under strict legal provisions, and the UK is not alone in this, and those limit museums' powers. International frameworks have often had more buy-in from source countries than from important market countries. And we have better legal frameworks for modern and future, although hopefully less and less, looting than we do for historic events. This being said, none of this necessarily is or should be static. It's only the law as it is now. And legislators and parliaments around the world are recognizing the shortcomings of that framework and the importance of a considered cross-disciplinary approach to reform. Thank you.
Thank you very much, Reya, for that overview. It's a sign of being an academic that one of my hobbies in the last 3 years has been checking to see if sections 15 and 16 of the Charities Act 2022 have been brought into force yet. We're still waiting. Gus, over to you.
That was formidable, Mona. Really kind of thorough and very kind of inspiring as well. Thank you very much.
Thank you.
And just wonderful to be here. Thank you so much for hosting this. My parents came to this country in the 1950s, and we lived, at least for the first 10 or so years of my life, in South London, and it felt like a different planet from the place that my parents would occasionally talk to me about as their place of origin, West Africa. My mother from Sierra Leone, my father from Ghana. And then one summer, my aunts came to visit, and they came not just with stories, but with cases full of amazing kind of fruits, which brought kind of smells and tastes that I'd never encountered, but also cloth. You know, lengths of kete and kente and adira and amazing kind of cloths, but also alongside them, incredible stories. And they would unravel a piece of cloth that may have sat on a funeral, on a coffin a generation ago, and they would tell the story of that moment and bring history to life. And it was history. I absolutely loved history even at that stage, but it was history unlike anything that I had heard before. And I knew immediately what it was that I wanted to do. And so as soon as I was able, I travelled, and I wanted to get to West Africa and to see these amazing kind of objects in the context in which they were created, to see the museums and the spaces where I could really embed myself in the rich histories. And I can remember going to the Ghana National Museum. I must have been about 16 or 17, saved up, and had took myself there, and with huge amount of expectation and excitement, only to see a space that was well loved, but in terms of being able to tell those histories that I had heard about and read about, it was just unable to do so. The material culture, the material evidence of those peoples just simply was not there in those spaces. And I had gone to West Africa in the hope of finding these kinds of anchoring histories, and had found that they simply were not there. And even though I had already at that stage had a kind of an understanding that I wanted to do something in the space of heritage, at that moment I also understood that there was a kind of a moral imperative, something that really kind of needed to change. That the cultural representation of the stories of African people is something that we in this country have the privilege of being able to explore in ways that so many people in their countries of origin just simply aren't. And as soon as I was able, I applied for a role at the British Museum, first as a volunteer, and then I became a member of staff in the education team. And I was part of the very first team that would move back the collection from the old Museum of Mankind, the Africa collection, back into the British Museum space. And it was a really deeply emotional moment to see those objects become part of that wider British Museum collection. And at their heart, and as I'm sure you visited that space, were those Benin plaques. And they looked absolutely incredible. But there was that lingering thing of how can we feel comfortable that we can tell these stories in such rich and wide ways when the countries of origin are simply unable to do so. And it always felt uncomfortable to me. And I would ask my colleagues and my superiors about when we would be able to begin to have the debates. When might it be possible for us to think about the return? And this was 25 years ago, and I was told not within my career. But I was aware that, as Mona was saying, that 1963 Act, that it did allow for the return of objects if they were duplicates. And any amount of research, I mean, you don't have to kind of, be studying for a PhD, will tell you that the BM had quietly returned some Benin plaques, or not returned them, but deaccessioned them, had quietly returned them in the post-war period. And that was because the way that those plaques are created, they are bronze or brass rather, but they are created using the lost wax process. And so they would have been originally hung as pairs, but every single one would have been created as part of a unique process. That to create something using the lost wax process, you create it first in wax, you then cover it in clay, you then heat that whole kind of body of clay and wax. The wax melts, and into the void you then pour the brass, the hot brass, and then it sets. And it's such a sophisticated technique that it can leave these absolutely kind of amazing brass plaques with incredible detail. And I'm sure if you've seen them that you would have been impressed. But the idea that they could have been duplicates is obviously something which is completely not the case. But some of them were returned, that there were precedents for the return of objects. And I began to kind of think about, how could we begin to shift hearts and minds? And one of the areas that I really invested time in was thinking about the situation in Ghana. I knew that the national museums there, that they had begun to think about how they might invest in building a new suite of buildings so that they might hopefully be able to establish loans and build a new collection. And I had maintained contacts with a number of curators there, and they were constantly in touch, asking about the possibility of us building curatorial partnerships, beginning to develop the sorts of conversation which they would hope at some point would end in the beginnings of loans and the return of those objects. And the situation in Ghana is, it's so personal to me. In 1873, the British sent a force of about 1,500 soldiers. And these soldiers were armed with Enfield rifles and Gatling guns. And they arrived on the coast over the winter of 1873. And by the spring of 1874, they've marched on the capital, Kumasi. They've burnt most of the capital to the ground. The palace, they've captured the king. He has been incarcerated, and they have stolen the contents of the royal treasury. A lot of that is then transported to the coast, and then from there it's taken to London. Some of it is sold by garrards in an auction, and it is spread to the high winds. Some of it ends up in the Wallace collection in the British Museum, some in the V&A, but some of it is auctioned and ends up in private collections. And the quality of what was sold, amazing gold pieces. If you ever get to visit the Wallace collection, go and see this exquisite life-size gold head that is crafted by an absolute master in exquisitely thin gold, incredible detail. That idea of Hegel's, that Africa was a place without history, without sophistication. If you get the chance to be in the presence of this object, if it doesn't move you, if you aren't impressed by the techniques, by the absolute commitment to the mastery of goldsmithery that thing represents, I will be stunned. And these objects that they then sit in these various collections for, what would that be? So 170 years. And the law doesn't change. We still cannot return these objects. But the will and the shift, I think that moment, and that George Floyd moment, that shift in consciousness across the world around issues of equity, issues of diversity, it had an impact on museums that was profound. And lots of the sorts of things that we had thought, well, we'll wait another generation, we'll get round to that. Suddenly, we realized we no longer could wait. And there was a sense of urgency, and lock gates that felt like they would not open suddenly opened. And the conversations that had been kind of put on hold suddenly began to move. The French had made promises. My old institution, the Smithsonian National Museum of Art, they returned objects. And then, as Mona said, the Horniman, Cambridge, the pressure began to mount on the nationals to actually do something. And the nationals that there are two acts, the 1963 Act and the 1983 Act, which make it very, very difficult for us to return objects. But even though we couldn't return them, there was something else that we could do. We could potentially broker the opportunity for a long-term loan of objects. Now, in the V&A collection, we had a range of absolutely exquisite things. Beautiful discs that are created for young people when they reach kind of 16, 17. And these are given as gifts, and they are meant to encourage confidence and growth. And these discs, a number of them had come into our collection, and they had been on and off display. But I, as part of the programme of events in advance of the opening of my museum, V&A East, I'd made a commitment to visit every single school in East London, so more than 80 of them. And one of the things I was really keen on is that we would take these objects out into these communities and give them the chance to handle them, to get up close to them. And some of those encounters were enormously emotional. I would sit in front of whole school assemblies in bits of East London where there would be, I don't know, 500, 600 students in a space, with only a handful of those students who weren't of African descent. And I would talk to them about the stories of these objects. And you could see in their eyes that they felt the sense of privilege to be close to these objects, but also the sense of them feeling, how can we have national institutions that are doing this on our behalf? It was apparent that a kind of time in which this had been acceptable had passed. And I was really kind of proud that we, working with the British Museum and also the Fowler Museum as well in the US, that last year that collection of objects were returned to Ghana, and they are now on display in the Palace Museum. We, limited by statute, so we could only return them on loan, but the Fowler returned theirs without any conditions. And they are on display in the palace. They've created a new space for them to be seen, openly accessible. And it's one of the things that I think over the course of my career that I feel most proud to have been involved in. And for me, a kind of point of closure on a chapter that began with my aunts coming into our living room and not just opening up their cases with amazing cloth and incredible gifts, but also with stories. And that these stories, it is wonderful now to see them in some way continuing their course in West Africa again. So I'll finish there.
Thank you, Gus, and thank you, Mona, for inspirational and quite moving talks. So we have time for questions from people online and in the room. If I could just ask one question to set the debate in the light of what you both said. We're a room of mainly lawyers. Is it good enough for us just to say there's some legislation that makes it difficult? Do you think we need to be campaigning, contesting, pushing more?
And who are you asking?
We, as a community,
society,
invested in this. Yeah, so it might be that I think it would be simplistic to say it's lawyers versus the institutions or those invested, because lawyers are very much invested in these issues. But do you think we should be owning this a bit more in terms of pushing for the minor change of bringing into force two provisions of the Charities Act that would enable ex gratia payments, and indeed the whole point of those provisions was to include the statutory charities.
But the objects are held in trust on our behalf.
Yeah.
So this is, I think, in large degree, something that we could all choose to lead into.
Yeah.
That it could be read more as being a communal responsibility because they are our property, they are public property. And I think, it's incumbent on museums to remind people of that. And I think we attempt to do so, that we have a kind of public responsibility that to talk about the value of collections and of them being owned by the public. But in this particular regard, we need to think about what are the things that we are comfortable to own and what are the things that we would actually kind of feel that there needs to be movement around. But that has to be part of a dialogue between museums, who are the bodies who are given the space within which these objects can be displayed, but we don't ultimately own them. And I think that, so I think it needs to be a dialogue between us, government, and the public.
I think I really agree with you, Gus, and I think it's very interesting what you say, because one of the things that has shifted the debate, and I see this thinking both as a lawyer and outside of it, that has shifted the debate in how we discuss restitution claims that have actually been alive for some of them more than 100 years, that have always been stuck behind the same legal hurdles, but now are coming back to life and are being put back on the table and discussed again, actually in many ways is grounded in the expectations of the public that museums serve. Because as you say, we hold that these objects are held in trust for the public. In France, for example, it's a very similar principle of inalienability, which means that public collections have to be held protected from the accessioning because of this idea that they have to be protected and available in perpetuity. But with all sorts of changes, political, generational, so many, the public that museums serve has evolved and their expectations in turn have changed. And that's translated in our conversations, but it's also translated into things like, for example, ICOM, the International Council of Museums, for the first time a couple of years ago, spending an unprecedented amount of time rediscussing the definition of a museum. That's been considered over the years, and it's a live debate, but hundreds of museum representatives came together and redefined the role of a museum, and it's the first time that words like ethics entered that definition. And it's an interesting shift to see, because it shows that it can very much be led by the public, and that in turn then changes the support for legislation, which is what we need to amend the framework that we work with on a legal level, because of course museums can only respond, echo that public pressure if they choose to, but the laws also need to change. But that all is connected in one and the same, I think, ecosystem that can support itself in all these stages.
I would argue, though, that museums have always had an ethical basis, and that, from our kind of our sort of founding drives. I mean, if one looks at the British Museum, its kind of founding charter, that it was set up not just for the sort of display, not just for the preservation and conservation of objects, but as a way of drawing us all into a kind of a single conversation. That it was in a period in which the very kind of sense of what Britain was actually coming into form, and it had an implicit responsibility, a sense of purpose that was beyond just the museological. It had a kind of moral framework that was implied by the universal nature of access, and I think with that comes a responsibility to think about issues of diversity, to think about issues of collection, to think about the responsibility to everyone who visits. That those things were implied from the very beginning. But I think over the course, particularly of the 20th century, that we have made commitments around those things which are kind of conscious and very publicly articulated, and it's important that we actually deliver on those things and be seen to be delivering and be proud to do so. And around this, I mean, it's unambiguous about the things that are right to do in this particular regard, and it feels intention for us to be welcoming particularly kind of children into our spaces if we are living with the kind of cognitive dissonance of feeling uncomfortable about some of these narratives. We need to deal with them, and I think I'm enormously proud of the work that the V&A has done around the Ghana collections, and actually shown leadership. It is not just that we have reacted to requests, that we have actually kind of demonstrated agency and leadership and proactivity. And I would think as a sector, we have been kind of, I think, ambiently being given permission to push forward and to really deliver in this area.
Yeah. Thank you. I have at least 31 other questions, but
Sorry.
could I invite any questions from the floor? I think our discussion just did cover a couple of the questions that have come in online. So as the terms of engagement, we want to be able to hear from as many people's contributions and perspectives as possible. So please make your contributions as short and focused as they can be. And I, again, thank our contributors on all of your behalf, so you don't need to begin your own contribution with that. So if people could raise their hands and just wait for a microphone to reach you, and I will also keep an eye on in the line. Yes, in the middle of the back row there.
Hi, I just wanted to know whether you found. Can you hear me? Okay.
Yeah, could you say your name?
Hi, I'm Poppy.
Hello, Poppy.
Hi. I just wanted to know whether you found that some countries are unhappy with the idea of a loan, and they'd rather just have the objects back. But obviously, you're limited if you're a public museum by statute. And if that's the case, how have you got round those issues, if at all?
Yeah, I mean, I can imagine that would be an issue in certain nations, and that we have to deal with these things on a case-by-case basis. We are in constant dialogue with nations all around the world in relation to our collections. What I can't do is to kind of talk about the nature of those discussions in this context, but we have to be kind of mindful of the way in which we actually present the kind of discourse around these things, because we want to kind of respect the fact that, as you say, that loaning back something to a nation that might quite rightly feel that those objects weren't legitimately here is not something that we can feel wholly comfortable about. But we have to, in certain circumstances, where the host nation agrees, to do the practical thing. And we are kind of very grateful to the people of Ghana for their generosity of spirit in this particular regard, in that they've been enormously kind of thoughtful and generous in actually kind of allowing us to kind of broker this kind of relationship that is based on loaning the objects in the shorter term.
Thank you very much. That was an exemplary opening question, Poppy. A question from Mona from online, from Maxim Barnes, for Mona. You mentioned requirements to document the history of objects that have left their home countries since the 1970s. What are the consequences for an object being flagged as having improper historical movements, or whatever technical term we want, and who enforces that?
Mm-hmm. It's a very good question. So the consequences usually are, and bearing in mind that this is within the framework of signatories to the 1970 Convention, UNESCO Convention, which means that all the obligations only apply to those state parties. But it means that, for example, if an object comes into the possession of a museum or a government entity in a country that's a signatory to the convention, they have an obligation to report that and deal with it in accordance with the convention's terms, some of which include returning that object. What's narrow in the convention is that this only applies to objects that are illegally exported and to objects that come from often national collections, objects that are put on inventories in the first place. So it's a little bit more narrow in that sense. In terms of enforcement, it relies on the countries that are signatories to the convention respecting it and enforcing it. That's one of the shortcomings of the 1970 convention and some other international conventions as well, that there's no enforcement body that sits above these states that can follow up on breaches.
Thank you. Any other student or junior members of the Inn who have questions? Yeah. First of all, and then we'll come to slightly more established members of the Inn. Yes.
Hi, I'm Sam Glamble from Six Pump Court. Just following on from your answer there in terms of enforcement, is there a recommendation that you would have if you would change the convention as to enforcement?
The Mona Convention.
I think in an ideal world, I think countries would have first and foremost very strict requirements in how they train their customs officers, their museum staff, etc., to make sure, because they're not easy conventions sometimes to apply, to establish that something is illegally exported in a market that for such a long time functioned on very little documentation is very difficult. So my first requirement would be very good training across the board, especially for customs officers who deal with all sorts of objects, including art. I do think there should be a body, maybe not as square as a court, but a panel of experts. And I say this because I think breaches and issues around the 1970 Convention and others can be cross-disciplinary in terms of how they need to be assessed. There's the central legal angle, which is, was this illegally exported? But how do you establish that something was illegally exported? When, for example, with the 1970 Convention, it's a little bit easier because that's events post-1970. But with the new European Convention, it's about to come into force. That applies to regulating the import of objects illegally exported from their country of origin. But that could be centuries ago. If you imagine an object of Persian art, for example, that's traveled across the Silk Road, was created in a territory which is now different, it's a different country, it's then traveled, different regions and communities might have a claim to it. It wasn't, the way that it crossed borders wasn't documented. How do you establish that it's illegally exported? That regulation has some exceptions when you can't establish exactly, for example, if you can't prove that there was any law that applied at the time. But that, whether that export was illegal or not, is technically a legal question, but it's also a historical question. You have to understand how objects traveled on the Silk Road, for example. So I think it would be good to have an independent body that can, answer these questions and create a form of enforcement. But I think it has to be cross-disciplinary. So I don't think it's necessarily a court, but a form of panel.
I can think of two nominees to that body. A question from a student online, William Crossman. Thank you, William, for your question. It might be for either of you. What intersections, if any, are there between the issue of art repatriation in this context and then also objects derived from endangered animals, such as ivory, so another sphere of legal regulation? So would you view legislation around the illegal wildlife trade and ivory trade as offering any, solutions or complications on these questions? I don't know which of you would like to answer that, or take it under advice.
Yeah, enormously complicated, and some of the most exquisite things that sit within both the V&A and also the British Museum are kind of things that have been kind of carved in bone, in ivory, and it is an area which is fraught, because I would loathe to not be able to see those things on display, and the learnings from both the history, but also the inspiration from being in proximity to things of that age and of that kind of quality is something that, even though I understand the wider kind of context, I think that in terms of historical materials, that I think we need to have some leeway.
Yeah, it's a very interesting question, because the tension in it is, the protection of something, either endangered species or history or ownership of an object, and access. And I think with access to it, by which I mean the public's access to that object to study it, etc. What's interesting with the Ivory Act that we have in the UK is that it goes beyond what is needed to protect further animals suffering for the trade in ivory. It bans the trade in ivory even in much older objects, and that's a political goal. In a sense, it's a goal of deterrence of the whole trade in itself, and that's something that's different to what we see in cultural heritage frameworks, because the limitations are a little bit more narrow often, not always, but often. So it's an interesting case study to look at from that perspective, in terms of looking at a piece of legislation that has a protective aim, and that's integral to the framework, but it also has the aim of deterring a particular market entirely.
Thank you. Another question in the room, if we have one. Yes.
Hello, thank you very much, Susan Edwards. Thank you for the lived experience, and thank you for the legal narratives. I think my question, probably an observation, is for you, Gus. I'm still holding in my head this wonderful gold face that's so intricate and exquisite, and the remark that you made that of itself, not only is it beautiful, it's an occasion for those who look at it to recognise and challenge their own cultural beliefs that they have been inculcated with about African art or any other art that is not Western. I'm looking from a Western perspective because I think you were drawing on that as well. So in looking at handing back the past, sorry, I was going to say holding back the past, if anybody knows that reference anyway, nothing to do with handing back the past, the cultural repatriation. To what extent are the cultural stereotypes, and I'm talking about the derogatory cultural stereotypes that Edward Said and Orientalism, and you talked about being so you'll be very familiar with that whole trajectory of cultural criticism. I mean, to what extent, if we are really going to be able to understand the importance of cultural repatriation, must we also challenge those many inbred notions that other societies that are not ours cannot produce anything that is of any lasting value? Good question, but thank you.
But I do think, if you look at the shifts in the curriculum, that there is a lot to feel very optimistic about. I mean, we have to kind of reshape the sorts of reference books that young people kind of can lay their hands on easily. But and also, I'd love to see kind of a whole new sort of generation of television and radio produced that is easily accessible. But I'm constantly in dialogue with teachers who are wanting to find the ways of really pushing the curriculum to tell the stories in exactly the way that reflect that shift that you allude to there. And I do get the sense that the young people in schools and universities, that they absolutely want to see it, that we are in such a different place from the point when I began my career, that it fills me with kind of real hope, because knowing that there is that kind of groundswell, that it means that institutions, like mine, that we cannot grow complacent. The wind might kind of shift politically, but I get the sense that this is now absolutely kind of part of the broader cultural consensus. And, we need to now give people the tools to actually kind of reflect this change, these sorts of changes in expectation. And if you look at the programs that are being delivered in places like the British Museum or the V&A, you will have seen a kind of fundamental shift in the sorts of subjects that we are really kind of celebrating as our core exhibitions. So I feel a sense of optimism.
And that ties in neatly to one of the questions from mine. We have about 5 minutes left of this discussion, but there will be discussion outside as well. So one of the questions is about the stories that museums tell and the greater context which has been added in the last 5 years. I realise it's not only 5 years, but generally of if we do see more repatriation on loan of these objects, the ability of museums to tell urgent stories to people here, is there a risk of that being lost, that opportunity?
Oh, I see.
Is that a concern, do you think? So drawing together a few questions.
I understand. Yeah. We are blessed at the V&A with huge collections which can tell the story of human creativity across thousands of years and almost in every area of geography. And we can be kind of generous with our collections, both in terms of loans and in other kinds of ways. And that there is so much that is duplicated and in store in museums across the West that we could really afford to kind of be in a place to furnish many of the museums across the global South that only want to be able to tell their own stories better. So I do think, of course, there is a moral basis for doing this, but also imagine if we begin to do that, how they will then be able to kind of refurnish us with new interpretations for the collections that we hold, because they are so kind of close to these histories.
Yes, wonderful. Okay, we have time for 2 questions in the room, and I'll take one more online. I saw a hand at back, Master Anger.
Thanks. I'm just asking this out of pure curiosity. So most of these artefacts were brought to the UK when it had an empire and was very rich on a global scale. And obviously Britain's place in the world has changed, and some of the countries in the global south or even former colonies are now much more prosperous with private collectors as well. Is there anything anywhere that represents English or British culture that we ought to be asking to get repatriated from somewhere?
I'll have to have a think about that and come back to you. But we can afford, the scale of our collections for a small nation in terms of population and geography, we have some of the best but also kind of well-furnished museums on earth. And having lived in the US and, I was a director of one of the Smithsonian museums, and seeing the levels of visitation there as compared to here, we have, I think, the very best museum sector on earth. And, that is reflected not just in terms of the staff, but also in terms of the collections and the programs. And we can afford to be generous. And I think this is one of the areas in which, we are looking for things to kind of rally around as a nation. This is something that we can really do. And part of that is in being generous and giving back. And that I think there is a really exciting chapter for British museology in which we kind of reach out and we give back and we build different kinds of relationships that I hope will be more equitable and also more fruitful.
So a question online, and then we'll come to the final couple of questions in the room before we go to the reception. So Mona, I think this is for you, but gosh, you may have a perspective as well. We've had a couple of questions referring to France. So you mentioned France in your talk, but particularly President Macron's is leadership the right word in this area? Does that offer us a model for how to think about some of these questions, or is is any exercise here somewhat contingent on the particular society we're repatriating from and to, do you think?
I think France was a very important, what happened over the past few years was very important in tipping the global debate as well, because a lot of the conversations, of course, were triggered, as you said, in 2020 with the George Floyd tragedy, but also in 2017 when President Macron went to deliver a speech in Burkina Faso at the University of Ouagadougou that promised to return cultural heritage that belonged to African countries and that is held in France. And it was a very optimistic moment because it was a very openly kind of broadly made promise. What was very good at the time is that he commissioned a report by two very good academics. It's called the Savoy Report, which took not just a legal approach to the analysis, but as I mentioned a few times, that important cross-disciplinary approach and made recommendations. This was, I think, the very good, energetic, positive, I think, beginning of it. What became difficult after that was that the recommendations that were made in the report were frightening to some museums, to even some members of the public. This is important also to remember in France, in some of the cases and the claims made for repatriation, the public has often been supportive. There have been cases where that hasn't been the case, even preceding 2017. And the report is incredibly rich, and it actually advocates a lot for a form of cultural cooperation and exchange and conversation. It's not just about returning or not returning objects, but the objects that it studied, that it pointed to, made up a lot of the collection of the Quai Branly Museum in Paris and a few other important museums in France. And the fright that it caused was that if it was executed, then suddenly these museums would be gutted of their collections. Of course, the other hurdle that the recommendations and the enthusiasm that followed in some communities for that report was the legal framework, which is not very dissimilar to that in the UK, and that national collections are also under lock in a similar way, in that works can't be deaccessioned. And the end result has been that so far only a handful of objects have been repatriated. Of that report, I think it's about 26 or 27. And that required a new law to be passed through Parliament. So it showed what it's been good for as a case study is it showed the kind of a good beginning and a good cross-disciplinary, rich, conversation-based approach to starting that debate. But it also showed the difficulty of following through when the legal hurdles are met, but equally showed that it's not impossible. It showed that what it takes is a law to be passed through Parliament. The problem was that the support could only be gathered for a certain number of objects, which is much, much smaller than what was recommended in the report. But it showed, I think, as a case study, the whole ecosystem of how these conversations happen. So it's being good in terms of sparking debate and showing. I know it has disappointed, I think, some, curators, historians, etc. But what's important for me, just as a lawyer looking at it, is it showed what's possible. Because the question I get asked the most is, are we stuck with these laws? And that showed that we're not.
Okay, we have to pick somebody. Hello.
Hello. I wanted to ask about the political implications of the restitution claims, because if we think of places like, for example, the British Museums, a lot of its objects are potentially not legitimately there. And we could hypothetically end up in a situation where the British Museum does not exist anymore. And I was wondering what that would mean symbolically in terms of Britain's position in the world and its soft power, and if those implications are obstacle to restitution claims.
Thank you.
I don't personally think that is a danger, and even if we go through a period in which a number of the kind of contested objects that we kind of all think about when the word restitution is mentioned, if they were kind of returned even on long-term loan or permanently, that the goodwill that would engender, I would imagine, would create opportunities for loans from those countries. And as an ex-member of staff of a number of museums, that the reserves that we hold, the richness of our broader collections of the work that isn't on display, that we are in positions to tell so many different kinds of stories, that we can be flexible and we can kind of move and we can acquire new objects and we can tell different kinds of stories. I don't see that as being an existential threat. I see that as being an opportunity for us to engage with thinking about how history changes and how we need to be responsible for it. We can't decouple ourselves from it.
Okay. It has to be a really short question if we're there. Thank you. No, I'm Jerry. So the person
Could I introduce an element of controversy for a moment and put a different?
One second. Henrietta, who are you trying to hand the question to? Yeah. So we'll take this question and then we'll come to you, sir. Sorry, I'm so sorry. But, and if both of you could be really short, we'll take a final question.
Very brief question. What can young lawyers, young prospective lawyers, do to help bring about the change that you both advocate for?
Thank you. And we'll take the second question as well, and then we'll...
I agree with most of the premise in relation to what is being said, but I want to put a practical point. Take Ghana, for instance. Ghana gets about 1 million visitors a year. London gets 40 million visitors a year. There's an argument, isn't there, for saying that these objects, many of which are very beautiful and very rare, and I understand all that you're saying, are much more widely seen if they're based in a country where they're looked after and they're seen by millions and millions of people each year. And I just wonder whether you haven't really addressed that if it's to be worldwide, why not leave them where they are?
I think doing the right thing is quite a powerful thing. Yeah, it would be nice if they were kind of... I personally think if they were actually in a country where you can't actually tell your own stories in your national museum, imagine if the kinds of things that you think are iconic, that underwrite British history, that they were all in Ghana. And they were kind of saying, well, they're seen by lots of people. But history and museums and art, the way in which it resonates for people who are genealogically connected to it is so powerful. And to see the tears of curators, of makers when those objects were returned last year, it was so powerful and humbling. And for me, as someone of Ghanaian descent, it was very hard for me not to feel emotional. This sense of resolution of a range of different debates, both of different narratives, some historical, but so many personal. We've got to do this because it's the right thing to do, irrespective of the numbers. And I think about kind of young people kind of growing up in Ghana today. They need to be able to tell their own stories and to feel that with pride. We've denied them that. I mean, if you think about what it must be like for, as a continent, for your history to be labelled as primitive, as simple, and then to not even have access to the very kind of material tools to be able to rectify that. We owe these people that, and it's a tiny thing that we can give. We have so many ways in which we can tell those stories ourselves. And it's not either or. There are enough of these collections to be able to do both. But I think in doing the right thing, it brings honour to the makers, to the history, but it takes away what I think is a kind of cognitive dissonance that sits under most national museums. And curators feel it as a weight, and I think that they feel some sense of relief in us doing the right thing.
Thank you. Yes. So we'll take one final question at the back, just while the microphone is moving out. One question online, just practically, is there curatorial preservation advice and support offered with the loans?
There is,
Yeah.
there is, but there is also expertise in these countries that they continue to make objects, in the same sorts of media. So, that there's no reason why they shouldn't be able to look after things.
We had a question about contribution heritage sector. So the very final question of this formal phase of the evening, and if you can keep it short. I will come to it in the next. Henrietta's been very keen for, and I have wanted this person at the back to be able to speak. Final question, short if you can, please. Thank you.
Great, thank you. I was born in Ghana, so I can speak to. We studied as a kid. I studied social studies, and we talked about the history of colonialism, but not once did we ever go to a museum or see an artifact. So it felt like fiction. Then I moved here, and we talk about World War I. We study about World War II, and then we had umpteenth trips to the museums to feel these things. So I can speak to the just how important the value of having these things back where they belong. But my question is, what can the creators or the originators of these artifacts, what can the global south, countries like Ghana, do to sort of be part of this conversation? Because we've talked about our government, our public, our institutions, and what we can do, but what can the global south do to maybe push legislation, maybe push sort of policy? How can they add to this conversation?
Thank you very much.
Well, in Ghana, I just have to commend the work that was done by government, by the king and his court, and by the National Museum Service, and 3 different bodies. And if you think kind of government, that they are thinking about kind of political terms and campaigning and what is going to suit the kind of headline for the National Museum Service, that they are wanting kind of institutions that work and to make sure that they can fill their cases with spectacular things, and for the king, the Asantehene, he is wanting the return of these objects, but that without ego, they worked together. And the degree with which they thought about the strategic long-term benefit of the Ghanaian people and were prepared to actually kind of not think about their own egos is actually kind of, I think, exemplified in the fact that they would accept this as a loan rather than a return. The dignity and the foresight is just, I think more than anything, that was the thing that made it made me kind of feel emotional, that the king would receive these things and he would be grateful for receiving something back that was taken from his people at the point of a Gatling gun. It's just incredible.
Okay, and then the final point to come back to the question of what young and maybe old lawyers can do.
I think there's so much actually that you can do, and I think 2 things you can start with is look at the blueprints for things for new frameworks, innovation legislation, even if it's not in the UK, that has worked, and think about how that could work here, because we often think of it's natural as a lawyer, you think of the limits you're working within, what we don't have, what the current framework is, but thinking ahead about the solutions, because it's often the solutions that are the most complicated, right? The restitution and repatriation debates, the balance between so many different things is, as Gus very eloquently also described, is very fine and requires different parties to make different compromises. But also think of the standards that don't necessarily come from the law, but come from practice, that change how collections are managed. And I mean also privately, for example. So some collectors that I and my team work with are exceptional in being proactive about commissioning research into their collections, investing in really good due diligence, settling claims in advance, claims that haven't they haven't actually been faced with, but approaching potential claimants, speaking to museums, curators, etc., to contextualize their collections better, because that's something that is extremely beneficial to their collection as well. Collections are both private and public. They aren't just about possession. They're also about the history around them, the knowledge that they hold, the research that they encourage, and being proactive in that sense. And I try in my work to encourage clients. You of course can't, force anything, and we certainly don't. But it's an important shift, I think, in approach to not approach this topic from a position of fear and concern that you might have, reputational exposure, you might be faced with a claim, but to actually look at a collection and think, okay, where are the gaps in knowledge that we have, and how can we fill those? And it can be an incredibly exciting thing to do. So that's another one, but there are so many more.
Thank you very much, Mona. So we'll hand over to Master Schumann in a moment for a vote of thanks. Just to note that this concludes the formal part of the questions, but our work is not done, because in the reception, rather like a game of Monopoly, we're assigned a table each with our names on, so those who are in the room can ask us further questions, and we can continue this important conversation, which is comprehensively addressed but not yet concluded. So I'll hand over to Master Schumann.
I fear I'm a living example of handing back the past. Because I was treasurer here a quarter of a century ago. And since then, this series has been started, and you can incidentally see a lot of background material on the Inn's website, which it is useful for you to look at if you're interested in this. But my function here is actually to express our gratitude to the speakers. Personally, what I found most moving was the emotional commitment towards objects in a particular cultural setting, and the emotional commitment that you clearly had in seeing this thing in this place. Whether it was originally stolen or whether it was originally sold for what appeared a fair price at the time is a separate question in a way, but the basic point, should everything or some things go back to the place where they started? Should pictures go back to the place where they were originally sold? These are all fascinating questions, and one well worth thinking about. And the Inn is extremely lucky to have speakers who can give of their time, and do give of their time, to stimulate our thoughts as to where one draws the line. And I suspect that their approach has been helpful to us all in saying, well, we don't need to have a rigid rule for everything. We can play things by ear, but we should be sensitive to other people's sensitivities. And that we can carry away. And I thank you both very much indeed for giving of your time and your expertise and your feelings.
Thank you.
Thank you, Master Schumann. Thank you all. Please join us for refreshments next door. Thank you.